Good evening, everybody. All right, guys, so let us kick off here. So I want to make it clear to everybody because a number of people have said to me, how can I have been cited? What have I done wrong? Now, please, you haven't done anything wrong. What I tried to do was just to get everybody's attention to make sure that you're looking at this. It is about you because in the application, in the appeal application that Marks, and it's just Marks, actually. It's really interesting. Nobody else is joined in that application. Marks is the only person who's bringing the appeal to the Supreme Court. And he's the only one he's the only applicant, which actually says a lot. So what he does is he cites in his application, he cites us as investors. And then later in his application, he makes the assumption that because we didn't physically submit an opposition in the first application, we actually supported his first application, and therefore we support him now. And I think that needs to be answered. I'm going to leave that to Hendrik to maybe address for us. But I think that we need to think about that. That is one of the things Hendrik and I had a discussion about this morning. We've also had a brief discussion with the liquidators about that during the course of the day today. And they, at this stage of the game, are definitely going to reply to the application. But we've also got to decide, obviously, there's still those papers still need to be thoroughly examined, but you are cited. And I'm going to just go there quickly. So let me just show that to you so everybody understands that. Now, please don't get mixed up with this stuff. Yolanda earlier said to me, you've been working with this day and night for a long time, and then you know all the facts, and then you talk too quickly and people get mixed up. So I just want to share this with you quickly. So in the actual application, you have the links to Bloemfontein. So here's the appeal that was set out by Marks. In the application, you can see the only person making the application, it's in the Supreme Court of appeal case. That's it. In the matter Clynton Marks. This was submitted on the 20th. It's dated the 20th of September. So we have until it's a month. And Hendrik, maybe you can just elaborate on that when we're finished. But in the respondents are the Registrar of the Supreme Court of Appeal in Bloemfontein. Obviously, they have to say whether this goes ahead. And then all the rest here, as far as I know, and I'm open to suggestions from you, Hendrik, if I've missed anything, all the rest are liquidators and liquidators' attorneys. And then here, this is where we are mentioned. All members and investors of Mirror Trading International in liquidation, fifth respondent. And it says, service via social media and MTI members chat groups. So by doing that, they have asked us to respond. And we need to, and I will leave this to Hendrik and the legal guys to get back to us in a final thing. But it is something that we need to think about. And it means that all of us who put money in, took money out, did whatever, have been called respondents to this thing. The problem that we have is further down, I'm not quite sure exactly where it is, but further down, they actually mention, here it is. They actually mention my name as well. So I am mentioned in this. But they also say because we didn't respond to the first application, because we were also mentioned in the first application, we agree with them that this is not a Ponzi scheme. Well, I'm really sorry, but I'm quite happy with what Judge DeVette said, and I'm also really happy that she had the guts to refuse the first application to file an appeal, which is what happened. But without going into all this detail here, I just want you to understand that this is an issue. Now, guys, so that you can understand what this is about, just to make sure that everybody understands. The first thing is that this does not affect the provisional payments. This appeal can be granted, and it won't affect the initial payments. So the payments stand by themselves. This appeal is something else. And we've got to understand that if this appeal, for some strange reason, this appeal is actually granted and they go to the appellate court, and the appellate court reverses the Judge DeWet's thing, and it's no longer regarded a Ponzi scheme, which is honestly highly unlikely as far as the evidence that I know about this case. But the situation is that if that does happen, then Marks can say, well, it was a legal business. The problem with it that he's got at the moment is because it's been regarded a Ponzi scheme, because it is regarded as fraudulent and all the rest of it, it is highly, it's a criminal act. It becomes a criminal act. And I want to take you back to, I just discuss with you very, very briefly that previously, when these sort of things have happened, the people who were involved as in the management or in the upper structure who didn't come to the table to settle the accounts were regarded as part of the actual scheme itself. So that really created problems for everybody. Okay. So it didn't create problems for the creditors. The liquidation stands alone by itself. But the thing is this, if just as an example, if this is continued and it carries that it is a Ponzi and illegal scheme, and we assist the police with the criminal charges, and the criminal charges are successful, then there is also the potential for additional claims from the investors themselves. So there's a lot of implications beyond this point, but that doesn't affect the actual liquidation itself. Okay. All right. So just that's one thing I wanted to just highlight. Hendrik, do you want to just comment on that at the moment? What I got wrong and where we are with that at the moment? I think it's important if you just want to comment on that, Hendrik.
Yes, Chris. The first thing is that parties that are cited there, the attorneys, as you saw, there was Mostert and Bosman who's appearing for the liquidators. Then there was the Villiers attorneys, which were appearing for Mr. Henry Honeyball, who was also a party to the court cases. And then EDJ attorneys, Elna de Jager attorneys, who were also representing Mr. Cecil Rowe and some of his people, who also were party all along in this lengthy court cases that has been going on. And yes, the appeal to the Supreme Court of Appeal is the last throw of the dice that the Marxes are attempting. So we'll have to see if they are successful or not. But as Chris correctly said, it does not stop the liquidation process. And also, it do not stop the criminal investigation into what transpired behind MTI and if there was people who will be held liable. But I will elaborate a little bit later on the webinar with regards to the criminal charges and how every one of you can assist the investigating officer to obtain more information which will be relevant to ensure that the prosecutor will be able to build a case against people that can be held liable. But also I will just go much deeper into that a little bit later. Back to you, Chris.
Okay. All right. Okay. So just to make sure everybody understands, that's the appeal. That is what's happened. We are cited. It has an effect on all of us in the long term. But as far as the actual physical MTI case by itself, it doesn't affect the liquidation of the business. The business liquidation is going ahead. What it can affect is it can affect the criminal case. It can affect other things as well beyond the liquidation, because the liquidation of the business stands by itself. Now, I'm going to, I think just briefly, I just want to also tell everybody that Christopher Ruiz has tried to get online with us. And he actually just let me know saying, please tell everybody apologies, struggling with the signal. Obviously, power outages. We'll try to log in and answer what can and need be claims, etc. have requested same to be recorded, and if needed be, please send message appeal. Won't work. Okay. So what Christopher says, in his opinion, he doesn't think the appeal will actually be successful. I am highly skeptical about that, but the court is the court, people. Everybody has the right to go to court with things, as the Marks do as well. Okay, so we'll leave it at that for now. So if there's any other questions or queries about this appeal, I think you guys need to tell us how you feel, how strongly you feel in the reaction. I will give you a link at the end of the webinar today. I will give everybody a link to the court documents, because you are mentioned in those court documents and you have the right to read those documents and make your own decisions, or take them to your solicitors and have them help you to decide. What I'm thinking of doing is we will follow on this discussion once we've had a little bit of feedback from everybody else, and have a discussion with Advocate Hendrik van Staden, and also have a further discussion with the liquidators. We haven't been able to have a thorough enough discussion with the liquidators about a way forward in responding to this appeal. I personally feel quite strongly we should respond to this appeal because we are mentioned in this appeal. So if anybody has, let's just stand still there for 1 second and deal with this and see if anybody has anything specific they want to ask about this. Yolanda, you've been doing the Q&As. Is there anything that we need to discuss about this?
I've heard that it is complicated. They do not really understand what you're saying. It in layman's terms, explain when and if we. Oh no, that's basically what it means.
Okay.
The appeal.
Okay, the appeal is Judge DeWet said she was asked to judge on whether this is a Ponzi or illegal and fraudulent scheme. And Judge DeWet presented all the papers. I think, was it 6 or 7 months, Hendrik, that she examined this? Is it 7 months, 8 months?
Yes, it was quite a lengthy time, approximately 7 months.
Yeah.
Before she wrote the judgment, due to the fact that it's a very unique court case in South African legal history, and also due to the quantum involved, or the amount of money involved, and due to the complexity of the MTI case.
So she gave her judgment. Her judgment was it's Ponzi illegal scheme, and then that was her judgment. So what happened then was that the Markses, who are now implicated as persons involved in an illegal trading scheme, and some of the other people who got involved in the actual distribution of the actual bringing in of members and things, filed an application to have that judgment, if they wanted to have the right to go to the Court of Appeal to have this judgment adjudicated again. That's basically what happened. And what happened is they have to go to the judge who originally gave the judgment. So they had to go to Judge DeWet. Well, what happened was Judge DeWet then said, no, I am not giving you permission to go to appeal. Now they have one other thing they can do. They can go to the Supreme Court and write an appeal, because it's been the application to have the Ponzi declaration overturned and the appeal has been denied, so that the Ponzi declaration went through, the appeal was denied. They have the right to go to the appellate court And I think it's the appellate court in Bloemfontein. And these are the papers they have filed now. And one of the problems that that I see in here is they cite us as creditors in this documentation and then make certain allegations as a result of having cited us. And that's where we are with that at the moment. So we are at the point where we need to make a decision whether the liquidators have sufficient support, and the liquidators have said that they think they have more than enough support to file their response to this and to this appeal, to stop this appeal, or whether we need to actually do something from a legal point of view. That's exactly where we are right now. So we're in the throes of that at this stage of the game. I hope that that was sufficient clarification. Guys, I don't want to stand on this too long. Please, if any of you want to engage in this, please just write up something for us. We will write up something around this and get it out to you as well. Hendrik, is there anything else that I need to mention there? No, I got it right, I think, yeah.
Yes, you got it right with regards to the appeal. And there's only one more court case, except the appeal, that is still laying ahead, and which is very important to all the investors in MTI, and that is the court case on the 2nd of November, which will be in the Cape Town High Court. And that's a declaratory order that the liquidators applied for. And that on the 2nd, the court will make a decision on how the amount of Bitcoin will be treated and which value will be used to determine the payouts that will be due to members who invested in MTI. And that will also give much more clarity on when you submit your claim forms, what will be the amounts due to you, because either it can be they use Bitcoin in minus Bitcoin out, or they use the rand value of the Bitcoin on the date you deposited it, and minus the rand value on the date that you withdrew your Bitcoin. And that is the other important case after this, except now for this appeal that's taking place from the Marxists.
I think just so that everybody is clear about that, at this stage of the game, a number of people, we have quite a few people, or a large number of people, who have already submitted their claims. Now, all those claims that have been submitted obviously have values in and values traded inside and values out, but not the actual trading profits, the individual values of what came in and possibly what was taken out, and then what the settlement amounts look like in value. Now, because the Bitcoin is involved, the actual decisions need to be made as to whether there is, what the values actually are that need to be paid out because of the Bitcoin evaluation and stuff like that. And that declaratory order is still outstanding. Therefore, although there is confirmation, and we have that in the claim documentation that we have submitted, which will make this whole thing easier, the moment that declaratory order comes out, the situation can immediately be evaluated in rand terms, dollar terms, pound terms, whatever the exchange rates are at that stage of the game. So what Advocate Van Staden was alluding to is this declaratory order is outstanding at the moment. That is now the only thing that is currently outstanding to do the final evaluation for the interim dividend payout. Now, in my discussion with the liquidators today, they have indicated that as soon as they have that declaratory order, they will start settling out the final figures with the individuals so that we can finalize what the figures are that are due, so that we can know what figure is due, and then do the various communication with those people that have submitted their claims through us and that we have been working with as well, and also anybody else. So this is all in the mix right now. But the thing that we've been saying, and Advocate Van Staden's been saying, and the liquidators have been saying, and everybody is saying, get your claims submitted. Because in the last video conference we had, it was very, very clear, made by Herman Bester, that he was looking at a payout of around between 40 and 60% of the value of the money you actually submitted into the pot. So if you submitted 100,000 Rand and you've submitted your claim forms and documents, you should be eligible for anything between 40 and 60,000 Rand payout in that initial payment schedule. Obviously, this can be revalued again and revalued again as they rake back more of these funds from the management and the people at the top of the net winners, because all of those funds haven't been evaluated yet, and the process of recovering those funds is ongoing at the moment. I will do a special discussion at the end of the video tonight with information that I have about how the net winners are being dealt with at the moment. Guys, don't put your head under a bucket or put your head in the sand like an ostrich and think you're not going to be kicked. I'm telling you, you have no idea what's coming at you if you don't participate in the settlement procedure. Because if you participate in a settlement procedure, it helps you and it also helps the liquidators, and it saves everybody time and money. And it doesn't look like you're hiding or running away. If you come to the table now and you say, listen, I was convinced this was a real scheme. I'm really sorry this happened. I was not doing this from the premise that I knew it was a fraudulent scheme. I am ready to settle. There is hope for you. But if you don't do that, you are saying, I'm running away from this. You're not going to catch me. And your details are all over the documentation. They know who you are. They are going to come and fetch you. And then you might end up having to answer a criminal case. Whereas if you've come in and you've settled, you've got cause to say, I'm sorry it happened. I've settled this out. I'm no longer thing. Am I correct in that, Advocate Van Staden?
Chris, I just want to come in here. There's two dimensions to everything. The one part is the civil part, which means that people who were net winners will be required to pay back certain amounts, or they can even settle. It depends on the negotiations they have with the liquidators. And it has been made clear by the liquidators that are willing to enter into negotiations. Whilst the criminal case is something different. Because many people invested in MTI did so believing it was a legitimate scheme or legitimate company. And the people on top who were actually the ones doing the misleading, or who might have been the people contravening various acts of South Africa, is then people who will be held liable. And that will mostly be the people who are in the management and the people who are actively involved in breaking the law, which could have been that they were doing money laundering, they were defrauding people, and they were running a pyramid scheme, basically. So that is why it's important, and Chris is going to make it available, that you complete an affidavit in which you state your MTI number, who introduced you to MTI, what was the amount that you transferred into MTI through your wallets, how much was the amount that you withdrew, and then so that I can determine who was the people who were actually pulling the strings behind the scene, and then they can use that to determine if these people were breaking the law. And I had a very long meeting with Colonel de Villiers, as well as the warrant officer who was assisting her. And as I said, made available the statements which we drafted. And they are very dedicated, and they want to ensure that they work in the best interest of you as investors, and to hold those accountable who were the reason why many people lost their money. And I see now Chris have also put Colonel de Villiers' telephone number there. Colonel de Villiers have asked me that we can distribute a cell phone number far and wide so that people can give her a call, and that she can even have meetings with you. Even if you were a person who were an integral part of the working of MTI, or do have knowledge of how MTI operated, it will be excellent to contact her and give her that information so that we can determine who is the real masterminds and who can then be held responsible. I'm sure Chris will also make Colonel de Villiers' email address available, Chris, as well as the pro forma affidavit.
Yeah. What
now, the pro forma also affidavit is only for South African investors, and you can take it to your local police station and have it commissioned, and then we can ensure that it gets sent through to Colonel de Villiers, and that we ensure that justice is served at the end of the day, which was in any case the reason why it was started in the first place. Chris?
Okay, so what will happen is when we will send out link confirmation for you if anybody wants to connect with Lieutenant Colonel de Villiers by themselves. But what we will also do is we will pre-format the affidavit, and then we will make, what I was thinking we would do is for all our members, we will help them to fill that in correctly, and then when it's ready, they can get it verified or whatever the procedure will be. We will work out a procedure with Colonel de Villiers for that, and then we will submit those on their behalf, and they can contact them directly then. But I think we'll help with that process so that we can get as many proper pieces of documentation and keep it on record. The advantage of doing it through our membership, the advantage of doing this membership is the advantage of doing this through the membership is that we have got the documentation that we have already done the claims and all the rest of that, and we've worked with the person's claims, so we know what their situation is and have already ratified all of that with the liquidators. So that helps support that documentation that that person is a genuine bona fide MTI investor that is putting in this claim, and that we can then check it against their records that we already have on the system, on our system. And we will then keep copies of that documentation to help as well to make that available for the SAP if somebody wants to go in that direction. We are not, we are there to assist with this, to get this on. And guys, it's important. It really, really is important that we do this. I just want to relay some messages that Christopher has. He's obviously being able to listen to us, although he can't link in. So I presume he's called in and he's listening to us. He says, first of all, that that from what we've discussed, that he believes that we should actually file some documentation regarding the investors in terms of the appeal. I'm just catching up with what he's given us to talk about. He says that he thinks it's important, and I also believe he's correct as far as that's concerned. And I also believe that Hendrik feels that we should get some input there which says that the allegations that are made by Marks in his application for the Ponzi scheme are incorrect and factually not correct, because of the way we've been cited in that documentation. The second thing that Krista has said to us as well is that he believes that there is a process for settlement. I know we have helped since the beginning. We have helped a number of people settle out, and I will address that at the end of the meeting, how that process works, and also bring in the information that Christopher has given here. And the big thing here is, if you come to the table and you are a net winner and you settle out, you can at least say, look, you can hold up your hands and say, look, I wasn't responsible. I didn't know that this was not a real scheme, because I did not know this was not a real scheme. None of us thought that the information we got when we logged into our panels and the bonuses we got and everything else we were told we had from that panel wasn't real. It was all just bogus information. None of us knew that. And I didn't know that either. I was nearly caught out by this whole thing as well. I was caught out by this because I invested. So I'm also in there. But I was at the point of starting to reveal it to my friends and network, and then the thing started to blow up. People were saying to me they couldn't withdraw their Bitcoin. Okay, I just want to stand at that for 1 minute. People, don't let anybody tell you this was a legitimate scheme. The management of the scheme, and I'm just saying management, knew it was not a legitimate scheme, because what was being reported on the computers to all their investors was not what was going on in the background. Those two things were two completely different things. There is no proof anywhere of a growth as a result of trading. And that's what they kept telling us. There's no proof of anywhere. There's been no proof of any growth as a result of trading. The value of Bitcoin went up during that period of time, which gave them some latitude in repaying us with our own Bitcoin. That was what was going on. But when people wanted to start cashing out, when it was the financial services in South Africa turned around and said, this is a fraudulent scheme, it's not registered, it's not correct, they raided the computers. At that stage, those people in management still carried on marketing and telling us they were going to get on top of it. And then days later, the Johan Steinberg vanishes, and they were still selling when he wasn't there. So how could they possibly have done that? It just doesn't sound right to me. So honestly, guys, I really think you've got to understand it. We were taken for a ride on this one, and we've got to just face it, sort it out, and help the police and the liquidators recover our funds. That's where we are at the moment. Anyway, that's me rambling on because I hear all the pain and I get told all the pain all the time. Okay, so here's Lieutenant Colonel de Villiers' number. We will send out communication to this page to everybody so you guys can come and pick it up. Here's the Supreme Court link to Marks's thing. And then there's this write-up I have on the wolves and sheep, which I wrote up before the declaration of the Ponzi. I haven't touched it. It's exactly as it was. And at this stage of the game, honestly, we just need to sort it out. Okay, so I'll just stand still there for a little minute. There are a lot of other questions that have come in. We've got a massive amount of people on this evening, guys. Thank you so much for coming. Really appreciate this. And I can hear Yolanda working her guts out trying to cover all the questions that have come in. Okay, so this is where we are at the moment. So we've spoken. The criminal case, you will have follow-up emails and information from us to help gathered this information, how we can help the police put this information together so that this can go through to the right people. And we will be discussing whether we should include in that process some sort of filing to the appeal as well. This is the appeal by Marks. Do we act? That'll be the next thing we need to talk about. And if anybody has got any ideas about what we should do about this, please get in contact with us so we can know how you feel about this. And I'm asking all of you to tell us how you feel about that. The appeal documentation is available. It's down here. A link to Marks Bloemfontein Supreme Court appeal document is down at the bottom on this page. And then what should I do as a net loser? Guys, simple, really simple. Contact us, get your claim in. There's money, there is potential funds coming out of this. You're not at a dead loss. We are at the end, towards the end of this now. And as Hendrik also alluded, we have one thing left to get. We just need a declaratory on valuation now. And then the liquidators can start paying up, start working out interim dividend payments. Okay. So, and don't let people tell you that the information that the liquidators have about the wallets and all the rest of that is inaccurate. The thing that really protected the payment process in the end was that the whole program was developed in India. And in India, if you are part of a fraudulent scheme, you go to jail. It's plain and simple, and it happens very quickly. Okay. So I would say to you guys, please, that was really good, because when this thing blew up, it was easy to get hold of the back end of this whole program by the liquidators, and they've got a pretty good system there. Whoever was involved in that did a good job. And most of the time we are finding that the nuances and differences between what the people thought they'd put in and the values and so on are really just minor amounts. But the records are pretty accurate to introduce you. All the rest of that stuff is very good. Don't let people tell you it's inaccurate. It's only inaccurate in as much as what you earned in profits, because that was all a lie. That was a lie. Didn't happen. But what you earned, what you put in, what you took out, that is known. That is known. But what you earned in profits didn't exist, because there were no profits. There was no trading attached to that program. It was just all rubbish. Okay. And it was there so that you could go and tell your friends how good you were doing and then bring them in. Okay. And then what should I do as a net winner is the last thing I will deal with tonight. But anybody who is net losers doesn't need to stay with that. I just want to talk about the framework of how to get that solved if you want to get it solved. And it doesn't go for the net winners, but we have got access to solicitors who have been helping people get this solved, and they are now asleep. Those guys are now sleeping at night, because it's settled out to something that is manageable. The thing is that if you don't come to the table, you end up with something that is not manageable. And Christopher is typing to me, I've got to tell you guys, they want to settle, they want to help you. They want to get this done. And he's busy telling me that in the background here. Okay, and I'll read you what he's just written. This is also good. He says, we also do not see winners as crooks. Investors would rather sort out and make an arrangement with liquidators and attorneys working with the file. Real people involved will be fought with all the night, and as far as it will be fought with the Insolvency Law, Companies Act, Prevention of Organization of Crime, Hawks, SARS, people who receive money, cash acted as a bank, most top winners. Okay, but I would say even to the top guys, this is where you should turn around and say, this is what I did. I'm sorry, let's come get a compromise. You got more of a chance of settling out than you have if you don't come to the table, no matter where in that structure you are. If they have to chase you, they're coming after you with a flippin' whip. That's how it works. Okay, guys, please don't find out later, you think. Anyway, two things here, please. Looking at this here, what should I do as a net loser? Get your claim submitted. Get hold of us. Let us help you. Let's get that sorted. There is hope at the end of this, and it's not a train coming out of the light at the end of the tunnel is not a train. There is hope here. There is hope here. And then what should I do as a net winner? We've spoken about that. All right. And then, guys, support at getacquit.com. We try and answer those emails on a daily basis. A little bit of a problem the next couple of days. We are going to be out of office, but we'll be back on Monday, and then we'll be going full steam ahead again. All right. So I'm going to leave that there, Hendrik. So we've spoken about, we're going to work at please send us inquiries. We'll send out what your affidavit should look like and how to work the affidavit. Please, guys, get in, do that. Anything else on that, Hendrik? You need anything else on that?
Yes, I just want to emphasize again what you said, that the members from Get Acquit must make it known to Chris if they want Chris to file an affidavit and to have a horse in the race in the appeal court case, because if you don't have a horse in the race, you're not in a race. Also, there are some people who might have different information than what the liquidators have, but that are very few and far between. And if there's any one of you who's not in agreement with what the liquidators have, you must make sure that the proof that you have on your side, you are able to give that information through to the liquidators so that they can verify and see. Because it is possible that there might have been a small hiccup or something that might have slipped in, especially in the last few days of the back office in MTI. So yes, it's possible that there might be some small hiccups, but make sure that what you avert or what you claim, that you are able to prove it. And let's start getting people to prepare their claims. And as soon as we get finality in the court case on the 2nd of November, Chris, we will engage with everyone again to give them feedback what transpired in court and how it will influence the claims that has been put in by members. Thank you.
Okay.
Chris, may I ask something, please?
Yeah, sure. Go for it, Anton.
The question I get the most, and how we can make it possible for between, let's say, Get Acquit and the liquidators is, now and then there's a document or wording going out that says 1,000 claims has been approved, and then 1,000 claims has been approved. Then documents come out, and everybody look for their own names on the documents, and they don't see their own names on there, so they don't know if the claims was approved or not. How can we make it possible between Get Acquit and the liquidators to maybe have a list of the claims that has been approved on the webpage or something where a person can search his MTI number or something to see, yes, my claim has been approved, I can sit back and relax for now, or I need to give attention to this?
But the way we actually work is that if somebody's claims are approved, we contact them directly and let them know. So we know when the claim has been approved, and where the claim is at that stage of the game, at any stage of the game. Anyone who is on the Get Acquit list will just go and they just ask us, and we'll tell them exactly what's going on. And what we also do is we make sure that the documentation, if there's a hiccup with the documentation, that we follow through and get that documentation corrected. The problem that we find most is people don't understand the documentation, and then they submit the documentation, and then the liquidators, if they goes directly to the liquidators, because people will say to me, I've submitted my documents to the liquidators, here are the documents I've submitted. And then when we go through that documentation, it's not correct. And then we have to go back, get the right documentation, restructure that claim, and then submit it to the liquidators. And then we have a whole system which works with the liquidators But I would not, I don't like the idea of telling the whole world whose claims have been approved. I work on an individual basis. To me, it has to do with the individuals. The other problem that we have, and this is one of the biggest problems, is a lot of people had their family and friends involved as well. And they've got like 6 other people below them who they've got authorities from to act on their behalf. And then we don't negotiate or discuss with the subs because they have given that authority to the main player. And then we only work with the main player. Because if that information is published, what's happening with the subs, and the main player isn't fully aware of what's going on, then it creates all sorts of friction and problems. So we tend to work on an individual basis. If you have an inquiry, submit it to thing. If that's the only way that I know we can deal with it within Get a Quid, and all the people who are members of ours, if they submit an email, mostly we'll answer it within 24 hours. We've got a bit of a hiccup at the moment because of holidays and there's rugby going on as well. So that's taking its toll on our workers, some workers especially. But that's thing. We are very much on top of it. And the individuals involved who are members, if they've got any queries or problems, please just get in touch with us. Guys, please, please, please don't hold back. If you don't know what's going on, just say, I don't know what's going on, help. And that's what we're here for. It's really important. We've got quite a number. I think we've got quite a large number of people now whose things have been sorted out with the liquidators. We talk to the liquidators once or twice, but we've got file sharing capabilities between us with them, and they can download the files, read the files, and then we say, okay, this set of files is ready. We send it in. They get back to us. Okay, this is the claim number, or this is the number that's been approved. The last stage will be now when we get to the stage where this declaratory order comes out, and we'll know what was gone in, what's gone out, what the Bitcoin in the account was, and then the declaratory order will get the final figures onto that. I hope I've answered that, Anton.
Perfect. It's understandable that we can't have a list then.
Yeah, no, I think it will be really dangerous because it's a breach of confidentiality. I think it's really important. One of the things we do is we regard the confidentiality of your information, of everybody's information, as one of our highest priorities, and we do a lot to try to protect it, to protect that information. Hendrik?
Chris, I've just received feedback from Christopher, and that people that do have problems, that list can be sent to the liquidators via Get a Quid, or by the members themselves. They can approach the liquidators, and then they can check on the system, which they call the Mars system. And then they can, after confirming that everything is correct in terms of the POPI Act, then they will be able to divulge information to investors who do not have access to their accounts. But it's important that it must be verified that the person who the account belongs to is the person who's requesting that information.
Exactly.
And as you said correctly, Get a Quid has got the responsibility to protect the personal info of the members as well as the liquidators.
Yeah, absolutely. Absolutely critical. We can't take chances with that. Okay, guys, Yolanda, some questions now. Where do we go?
I have a person asking, you said that the management was involved. That was Mr. Marks. So why are we trying to help him again? So I'm trying to explain that we are opposing what he's doing. So it's not helping. it is against, we are acting against what he's doing, not promoting it.
The thing that Clynton Marks, what he's trying to do is to stop the Ponzi scheme declaratory that has been given by Judge De Wet. And he's now asking for, he's now cited us as respondents in that application to appeal. And we are against that. We are saying, let it be. It's a Ponzi scheme. It's fraudulent. It's not going to change. That's what it was. And there's no evidence whatsoever anywhere. No evidence, apart from a whole lot of fluff and nonsense talking by a lot of people out there. There is no evidence that this was a profitable trading scheme, or that a real profitable trading scheme existed, or that their bot, which they talked about, existed. It didn't exist. They couldn't produce it. And the problem was that the number of Bitcoin owed by Mirror Trading International to its investors was less than the Bitcoin it had control over. That is a liquidation situation. End of story. So don't, you see, all these people, and this is our problem. The people who sold you this stuff, who came to all of us and sold us this stuff, are the people who made money out of it. Now, those people are trying their utmost best to feed us disinformation and stop us from getting this thing resolved. That's our problem. And the problem is, by the nature of it, those people in general who sold us this stuff are marketeers. They were marketeers. And I think a lot of them were innocent marketeers. Please, guys, don't think that everybody who sold this stuff was guilty of fraud. They were drawn into a fraudulent situation, which they were not aware of. But it still was a fraudulent situation. Now, maybe Hendrik can answer this, but as far as I understand it, in the law, if you are part of a fraudulent situation, you actually can be charged with fraud, because your excuse for not knowing it was fraudulent doesn't hold water. Now, I think Hendrik can be softer than I was here. But the thing is, guys, listen to me carefully. All these guys with their groups and all of that umfa this whole story about being a Ponzi scheme, have not been able to produce one shred of evidence that there was a trading bot, actual real trading bot, that there were trading accounts that made profit, that there were more Bitcoin in the pot than what was due to the clients at the time of liquidation. That's why the company was liquidated. Now, if Mr. Marks or whoever, Johan Steinberg, or I'm not going to say more names than that because those were the management. If the management had the money, why didn't they come to the table and say, don't worry, guys, we can settle these accounts. Let's stop the liquidation. We can pay you all out. Here's our offer. Why not? Why all this shenanigans and nonsense? It doesn't make sense to me. And the problem is now the marketeers get involved in supporting these people by trying to sell disinformation because they are marketeers. Instead of standing back and saying, guys, I'm sorry, I got involved in a fraudulent scheme. It was a mistake on my side. Let me help you sort out your accounts and get your money back. And go to the liquidators and say to the liquidators, look, guys, I didn't know this was going on. Help me so that I can repay you. I owe you 6 Bitcoin. This is what I owe you. What if I gave you 4 Bitcoin? And if I paid you in 3 years' time? Yeah, fine. Let's sort it out. Let's get it over and done with. That's it. Job done. Now your conscience is clean. You can sleep at night. But to go around and talk nonsense about the information, it's not the way to get this sorted. And your problem is those guys that are controlling the information at the moment are the guys that don't want this to actually get finalized. Sorry, Hendrik, you wanted to say something. Sorry, Hendrik, really sorry about that. Hendrik?
Yeah, Chris, as you said, ignorance of the law is not a valid defense. But I would, however, I'm of the view that they will be focusing on the people who were in charge of the management. And as Christopher also said correctly, the people who contravened the POCO Act, Insolvency Act, Companies Act, or people that were going all out there to defraud people. So if it was yourself who had 5 family members underneath you, and you did not have your budget accounts and your CAT accounts with the aim to defraud the system, I don't foresee that there will be any criminal charges brought against you as such. So then you can at least sleep with a mind that they won't be coming after you. And yeah, that's why it's very important that we assist the South African Police Service, especially the Hawks, to make the determination that who was the masterminds, who was the people who were out there to defraud others, and who were the people who were contravening the various acts of the Republic of South Africa.
Okay. Okay, guys. Yolanda, any more questions? Sorry, I got carried away there, but this thing hurts a lot.
Yes, that need to just make it clear again. If a person contacts me on behalf of their spouse or parent or whoever subscribed on their behalf, I cannot discuss the claim with that person. I need to have the authorization of the account holder. So the person who subscribed to Get Equid originally, I need the written authorization of that person to be able to deal with them.
Yeah, there is a legal process in how that works. So if I have written in my children and my children are now 18 years old, and I want to represent my child who I signed up to this, I have to go to that child and they have to give me an affidavit that I'm allowed to act on their behalf. And that has to be properly notarized and all the rest of it with the proper information. And then I can act on behalf of that child. If that child is 10 or 12 years old, we need proof that that's the age of the child. And then we can set that up and sort out, because all the funds came from my account. There's all sorts of things like that that are involved there. But the best thing is to contact us directly and talk to us about your unique situation and how you got the dog onto the MTI account as well. Okay. Anything else there, Yolanda, at this stage? I just want to deal with, just at the end, I'll talk to the people who are net winners and just talk about, I think it's really important to see the framework around that.
Just people want to know how they will be paid, and obviously the Bitcoin increase in value. So when they invested originally, since then the Bitcoin has increased in value. So they want to know whether they will receive payment of the bigger amount.
Well, it's really simple. You will have put in a certain amount of money in Rand terms, which will have been converted to Bitcoin at the time that you deposited. And that will be what will be accredited to your account or your stake in the pot. And then when that stake in the pot was sold, that obviously brought in a lot of revenue. So that pot will then be divided on what the valuation is of what you put into the system, or what you put in and took out of the system. So all of that will come into play into what your valuation is. But that's what the declaratory order is for, is so that they can be really clear, because this has never happened before. They've had to go to court to get the declaratory order so that they cannot be challenged on how the evaluation is done. I can understand that had to be done. Guys, we are honestly, I can only say to you that since our last webinar, we've had a lot of really good communication with the liquidators so far. We don't always agree with what they say, but we argue these things out. So, but I do want to say at this stage of the game, please don't lose hope here. This at the moment, it really is, and Herman Bester has on a number of occasions verified that there are substantial payouts possible for the people. The problem that they can't put a figure to that is because obviously more claims are coming in, more claims are being verified, and they're pulling in more funds as well. As the people make settlements and things like that, there are more funds coming into the pot as well. And obviously, the more they are able to go after the assets of the people who did the funny business, who aren't coming to the table, the more funds will come into this pot. So there'll possibly be 1, 2, or maybe even 3 payments that will follow. And your claim is always the same. Your claim is running forward in. And if you don't get it in the first one, well, possibly you'll get it into the second one, or the third one, maybe, if you just don't get it done in time. Then you'll get the third, you'll get a little bit from the third pot, but it'll get less and less as it goes down the line, I think. I don't know if, I don't know, it could go more. Maybe we can even ask you on Stoneback to come to the table. But anyway, that's where we are with that. Okay, guys. Yolanda, can I wrap up on the net winners? Hendrik, anything else on the net winners at this stage? Anton, please, anything else on the net winners at this stage?
Well, from my side, the net winners, if it's a very small amount that you are a net winner of, I don't foresee the liquidators coming after you. If it was $100, it's not worth to go all that legal fees to recoup a small amount for liquidators, because it won't be in the best interest of the net losers, because the cost involved will be too much.
Yeah.
Then also, as Christopher Roos alluded to earlier, net winners are able to approach the liquidators and come to agreement, which information will then be handled as confidential, and then they will be able to reach an agreement for a lesser amount if they don't have the full amount available anymore, so that at least the net losers can get out some of the funds that are due to them.
Okay. All right. Now I just want to talk to this, guys, and this is a discussion. I'm just going to talk to a process here, and I want you to understand the process. We've been through this process with a number of clients. Client comes to us, he says, look, I'm a net winner. I don't know where I stand. How do I go about it? Or I have been subpoenaed. I have been, is it a 417, I think? Then I get their 417 inquiry transcript. So they get a 417 inquiry transcript, and they now have to appear with the liquidators. That's where the process starts. We then help that person put together his accounts, that how things happened and where he is with that. We talk to him, get as much of the information together, and get it ready for submission to the solicitors. We then submit the documentation to the solicitor. The solicitor will then come up with an agreement, and then that solicitor will then have an agreement with the client to represent them with the liquidators. And then the negotiation starts. They then settle out on what the amount due is from the net winner. And then the net winner, with his solicitor, negotiates a settlement with the liquidators. And these settlements can include, the settlement discussion can include the amounts. In other words, they are negotiated. What the amount is that is due, that is negotiated. The repayment procedure and format that amount can be repaid and settled out. And then the whole thing is put together, and the documentation is presented to the net winner. He at that stage will work with his solicitor and come to an agreement with the liquidators. And the beauty about that is the thing is final. That's it, job done, over. And also that person now has a standing to officially say, look, I didn't know what was going on. I didn't understand that this wasn't real, but I was happy to settle out, and I have a settlement agreement with the liquidators. And that puts that person in a different light and a different perspective. The alternative is really simple. You put your head in the hole as an ostrich does, and in the end, you'll end up in a situation where somebody's just going to kick your backside, because now you don't have foot to stand on. So I really do recommend that these people who are spreading all this disinformation are winners. This will not go away, will not stop, because there are many more people that have lost money and are net losers than there are net winners. Okay, for there to be net winners, for every net winner there has to be 5 or more net losers. That's how it normally works. That statistic doesn't change. So if there are 50 net winners, there are going to be 5 times 50 net losers. That's 250 net losers at least in that pot. That's pyramid schemes. So, okay, so please, guys, and if you need help with that, if your information remains confidential with us, we honestly, we will not allow that information to go out to anybody. And what we negotiate and discuss with you, we're very secure in how we deal with that. We really do our best to keep it secure. All right. I don't expect anybody to have questions about that. Maybe some of the net winners might have some questions about that. Hendrik has said, guys, his indication is that he's happy to help us to prepare our response. And we will negotiate that and let you guys know about that. Hendrik has offered to do that for us. So I'll have a discussion with him about that and let everybody know about that. But please, guys, if any of you want to, we might go out to you and say, okay, please fill in some forms for us for this appeal, because I think we should submit documentation. I really do think we need to do that. But I'll get back to everybody on this in the next couple of days, so everybody knows what's going on as far as that is concerned. Christopher, I have nothing else from Christopher at the moment. Yeah, got that. I think what Chris is trying to get across, which is really, really important, is that we've got to remember that the liquidators will try to help us settle these accounts out, both for the net winners and the net losers. And please, guys, I've had nothing but good reports from the net winners who we've worked through this process with. They were in a very, very I am lost situation and have subsequently actually had it settled out. There's always a negotiation, right? There is nobody. If the liquidators got everything they would wanted, then the net winner wouldn't get what he wanted. But if both of them compromise, then you meet in the middle and it makes a difference and it helps everybody out. Okay, guys, I'm going to wrap up now. Yolanda, is there anything specific that needs to be answered? Yolanda?
I'm just replying to lady who said, so dan kan ons nie GetEquid ook gebruik nie. So then we cannot use GetEquid as well. Basically, what I want to tell the people, you can do that as well. If they go through GetEquid, we can find out exactly what the situation is. If anything any of the documents are incorrect, we can assure that they have the correct documents submitted. And if there's any questions or anything like that, they can talk to me. I will be able to assist them. And we will be able to update them on the status of their claim. So that would be, so we will be able to assist them.
Yeah, I think one of the things I just want to say to everybody is Yolanda is not a lightweight. She has a South African law degree with honors. So she has a full South African law degree with honors. And she also has a UK law degree. So guys, she does know something about the law. It might feel that she's just an admin person, but she does that really well because she has got a lot of background in it. And honestly, every time that she's put together a set of documents for a solicitor, there's been very, very little queries about it. So yes, we can put those documents together, and it does help you a lot because it saves you solicitor time as well. So if you've got a situation, talk to us. Any winners who need help there, and we will try and find you the best possible solicitor, because we work with these solicitors. We prepare your net winner documentation, so that which we then verify and ratify with the liquidators as well. So we were all putting it all together in a format that everybody is already happy with. Then we pass it on to a solicitor, and then the solicitor will then take it from there and carry on with it. But the initial groundwork, we help you get the groundwork right, who you represent, what you represent, where you are, and we talk it through. We've done a number of these already. Okay. Christopher, I wish you would just come online and talk to me. All good, see, communication's done better. Okay. Christopher is promoting that that we work out ways to work with MR system as well, that everybody gets onto that. And one of the questions was, is the money in the interest-bearing account? The answer is yes, it is. And Christopher says that if we've got overrun on questions we can't answer, we should forward them to him and he'll do his best to get them answered for us, guys. So Mr. Roos, thank you very much for your clandestine participation tonight. Really appreciate that.
Chris,
yeah, sure.
I would just like to thank you as well, and Yolanda, and especially Advocate van Staden.
Yeah.
Since day one, he has been part of us and assisting us. And as far as I know, without any compensation. I've seen many people come in, big mouth, they're going to support us, stand by us, and they fall out of the bus somewhere. And Advocate van Staden has been standing behind us from day one. And I've met Christopher Roos as well. He seems like a very good guy and he stands behind us as well. And I know Advocate van Staden and Christopher Roos are in communication, and so thanks to them as well.
Now I can only give credit to what Advocate van Staden has done, and Christopher Roos has been he's been a, how can I say, a soft hand on the liquidation as far as the creditors are concerned. He's done a lot for us there as well. So thank you for that. But Advocate van Staden has now thrown his hat in the ring again tonight, guys. And honestly, this is really a good thing that he's done that. I think we'll talk about it and get back to you what we need from our clientele to put this to bed. Okay, guys, thank you so much for all your support as well. I just want to say to everybody who's supporting us, there's a lot of people out there who are supporting us. Thank you for that. We really, really appreciate it. Okay, that's it. Thank you, Advocate van Staden. Thank you, Anton. Thank you, Yolanda.